Welcome back to First Issues. In our previous episode, we kick-started a three-part series in which we discussed the remnants of intellectual property as a relatively new concept in Botswana. We started the series with copyright, which, according to Copyright Administrator at the Companies and Intellectual Property Authority, CIPA, Timothy Moalusi, is the exclusive right acquired by authors, artists and other creators for their literary and artistic creations, such as novels, musical works, drawings, photographs, architecture, films, video games and original databases, amongst other examples. This system protects these works from being pirated or used illegally. In order to acquire a copyright of your work, Geeting says there's no need to register with our office as it is acquired automatically if your works are originally yours. Tonight on the program, we're talking about industrial property with the Registrar of Industrial Property at the Companies and Intellectual Property Authority, CIPA, Timothy Moalusi. He shares that industrial property is a term that refers to rights given as an exclusive monopoly on exploitation and is granted upon registration. Industrial property rights in Botswana are protected through the Industrial Property Act, which includes, amongst others, trademarks, patents and traditional knowledge. Here's Timothy to explain all this in simpler terms.
A patent is actually a grant by the state, an office like CIPA, where we grant rights to an inventor who has actually developed a technical solution to solve a problem in any industry. And therefore, when now that solution is put into a patent document that you then apply to a government office like CIPA, and then we can grant a patent. And a patent is actually protected for a period of 20 years. And then for something to qualify as a patent, it has to meet a criteria of three things. So it must be new. That means that invention must not have been found by anybody else in the world. And then it must be non-obvious to somebody who's skilled in the area of technology or invention that you are working on. And then it must be industrially applicable. It must be able to be used in industry. And therefore, in that sense, that's how you will get a patent.
So Timothy, what are some of the local products that can be protected through the intellectual property system?
I believe a lot of products can be protected through the intellectual property system. As an example, I know that we have a Kalahari brick technology, which was actually protected as a patent by Botec, which is now under B3. So they developed a technology that allows you to make a brick using the Kalahari sand, which is something that is not common because usually bricks are done using river sand. And therefore, they were able to develop that technology that allows bricks to be made out of that sand. So I guess across many industries, largely medicines, those type of things can be protected through patents.
At this point, I'd like for you to talk us through the process through which one has to go through to protect their innovations. What are some of the key factors that innovators need to be aware of to register their innovations?
If you want to protect your innovation, obviously, first of all, is that idea that you have, you must transform it into a tangible product in terms of either a prototype to say, this is how this thing works. And then you apply for a patent here at CIPA. There is a process that you'd have to develop your invention into that document. Then you make an application to CIPA. to say, please grant me a patent on this invention that I have. And therefore, once you apply, we then examine it. We look at it to say, does it meet the requirements of our law in terms of the 3 factors that I talked about. We also look at other factors, for example, that things like, for example, if it's software, as an example, we do not protect it as a patent, but as copyright. So you need to look at all those things to say, does my invention fit as a patent? And then once we examine it, then if we are happy that it meets the requirements, then a patent can be granted to you for a period of 20 years.
Timothy, as Botswana prepares to be a net exporter instead of a net importer like she currently is, what are some of the key considerations that local companies need to be aware of as pertaining to intellectual property rights? And can they get their intellectual property protected in other countries?
Yes, in other creations can be actually protected in other countries. If you look in the area of trademarks, which are part of industrial property, if you want to then send your product or sell it or market it in other countries, then we can be able to facilitate you in the region. We have what is called the Banjul Protocol, where you can be able to protect your trademark in 18 countries. And internationally, we have what is called the Madrid Protocol that allows you to file that trademark internationally in almost 182 countries. And then we can also, with patents, you can file your application through another protocol called the Patent Cooperation Treaty that allows us to, you as an innovator, to file your patent through us, and then we can facilitate that it is then sent to other countries. This is important in the sense that intellectual property rights are territorial. You are only protected where you have filed. So therefore, if you file in Botswana, your protection is granted in Botswana. And then if you want to go to other countries, that means through the different protocols that I was describing earlier, we are able to help you file in those countries. And those countries also have to assess your application to say, does it meet their requirements? And if they are happy with it, then you can get protection in those markets.
Intellectual property rights are given for a limited period. However, trademarks or brands are one such intellectual property that can be renewed indefinitely. So how can companies leverage on this to make sure that their innovations and creations are sought after or continue to be sought after in the market?
Trademarks actually give you legal rights over your brand or what you use as your product identifier. And therefore, it means that, as you've mentioned, for you to keep it continually, every 10 years, you must apply to have it renewed as that particular right. And that gives you the advantage that then, as long as every 10 years, after every 10 years you renew it, it will be able to continue to remain valid over the life of your business as long as you renew it every 10 years. And that is an advantage in the sense that trademarks play a critical role in marketing because they are the ones that you use to identify your products in the market. And therefore, as you build your brand over time, you are creating more value. And therefore, as you create more value with your brand, it means that you then have an advantage of even increasing your market share. You have an advantage of even using it to license it to other people and make royalties out of it. You can even use it to franchise depending on the success of your brand. So that protection, that ability to renew it over every 10 years lengthens your capacity to build a brand and to be able to create more value with it.